Okay. Good afternoon, everyone. Welcome to today's Housing Law Updates Lunch and Learn session. My name is Angie Pham, and I am the Community Development Worker at Waterloo Region Community Legal Services. It's my pleasure to introduce today's presenter, Kristen Thompson. Kristen has been working at community legal clinics for over 12 years, and before entering law school, she had attended Wilfrid Laurier University. She now specializes in housing law, income maintenance, which includes Ontario Works, ODSP, CPP, etc., and consumer protection. Kristen is also tenant duty counsel at the Landlord and Tenant Board. Thanks so much, Kristen, for joining us today. As a disclaimer, this session is being recorded and will be posted to our YouTube page. If you have any questions or comments throughout the presentation, please feel free to drop them in the chat box. In the interest of time, we will be answering questions after the presentation, and I will also send out the slides and link to the recording afterward. Thank you again for taking the time to join us today, and I will pass things over to Kristen.
Thanks, Angie, and thanks everyone for joining us. I'd like to start by doing a land acknowledgement. We acknowledge that we are on the traditional territory of the Anishinaabe, Haudenosaunee, and Neutral people. Waterloo Region is situated on the Haldimand Tract, the land promised to the Six Nations that includes 6 miles on each side of the Grand River. We thank them for allowing us to do this good work on their traditional lands. And I would also like to refer you to this website, native/lands.ca. It's a really great website that gives you maps of the world where you can learn about territories, treaties, and languages. I think it's a good step towards strengthening the bond between others and the land. In regards to our presentation today, this is an overview. We're going to first be talking about who is protected under the Residential Tenancies Act. I'm then going to talk about evictions, so the common reasons for evictions, the Landlord and Tenant Board eviction process, and COVID and evictions. And then lastly, I'm going to talk about the recent RTA changes. So these changes happened within the last year or a couple of months, but I also go back to some of the previous changes as well. So the recent changes are the standard form lease, 2022 rent increases, landlords pursuing a previous tenant, and increased compensation in bad faith evictions. So those are those evictions for the landlord or purchaser's own use, or for rent evictions, a tenant being evicted for renovations. So if you've heard some of my presentations before, I'd say the first 20 minutes is a basic review. Perfect time to make your lunch if you know the basics of the RTA. And like Angie said, at any time, put your questions in the chat box. And at the end, we'll be answering questions, and we'll also have a time to discuss specific questions or share experiences. I'm going to start by telling you about the Residential Tenancies Act. So that is the act that guides the relationship between landlords and tenants in Ontario. There are certain persons that are protected under the act, but there are certain exclusions as well. So most tenants are protected under the RTA. So that includes when you rent an apartment, when you rent a condo from a condo owner, or when you rent an all seasons mobile home. It includes rooming houses. So when you rent a room in a rooming house, it includes retirement and care homes, long-term rehab or therapy services. So generally, if it's over a year in length. It also includes rent geared to income units and nonprofits. There are, however, some tenants that are not protected. So if you share a bathroom or a kitchen with the owner or certain close relatives of the owner, you're not protected. Those staying in hospital and long-term care are not protected. Emergency shelters or the short-term rehab or therapy services are not protected under the Act. And what is Residential Tenancies Act protection? Basically comes down to 2 things. So the first thing is you have a right to an eviction in front of the Landlord and Tenant Board. So to go back to the other circumstances, so for example, if you share a bathroom or a kitchen with the owner or close relative, you do not have a right to a Landlord and Tenant Board eviction hearing, meaning that you can be evicted at any time for any reason. It also means that most tenants have the right to enforce tenant issues in front of the landlord and tenant board. So if a tenant has an issue with maintenance, the landlord illegally entering, so not giving the 24 hours written notice for certain reasons, the landlord harassing or being harassed by another tenant and the landlord not taking action, and illegal rents and charges, a tenant can bring their own application to the landlord and tenant board for these issues. Here are some of the common reasons why a tenant can be evicted. A non-payment of rent, which is we refer to as an N4, interference with others, so that can include noise, behavior, tenant-on-tenant conflict, so conflicts with the neighbor next door, and damage, those go into an N5, illegal act or serious problem, the landlord or purchaser requiring the unit and therefore evicting a tenant, the N12, or the N13, renovations requiring vacant possession. This is what a typical notice looks like. So the tenant would get a copy of this notice. It is quite a scary notice to get, in particular that box in the middle. This is a legal notice that could lead to you being evicted from your home. I am giving you this notice because I want to end your tenancy. I want you to move out of the rental unit by the following termination date. And the termination date is usually somewhere between 10 to 20 days after the landlord gives notice. However, the stipulation is the tenant does not have to leave pursuant to the termination date in the notice, although they may choose to do so. However, they always have the right to a landlord and tenant board hearing. If any of your clients do get an eviction notice, this is a good time to contact us to review that notice with the tenant. And this is the eviction process. So like we talked about before, a tenant first gets the notice of eviction. Some notices can be voided. So for example, if a tenant receives that N4 for arrears, the notice can be voided. It can go away if they pay the amount of rent owing. It can also be avoided sometimes by stopping the behavior or by paying that amount for damage. So after a tenant gets an eviction notice, the landlord can apply to the landlord and tenant board for an eviction hearing. Right now, the eviction hearings are taking place online. So a tenant would either call in or Zoom in. There are essentially three things that could happen if the landlord and tenant board orders an eviction. So first, the tenant and the landlord can enter into a mediated agreement, or the landlord and tenant board can order an agreement with terms. So certain terms might be a repayment plan, paying your rent on the first and then mid-month paying an amount towards the arrears. In a behavior case, it could be certain behaviors that have to take place, not making excessive noise after 11 p.m., for example. A standard order is 11 days. So in particular for an eviction hearing for arrears, a standard order is you have 11 days to pay off all those arrears. Or there can be a delayed eviction order. I'm seeing more of these now. So for example, if a tenant is going to the landlord and tenant board for arrears, they cannot afford the unit, but they need a bit more time. I've seen the board delay the eviction up to 1 or 2 months. So you are evicted, but it's not the standard 11-day order. Instead, you've got until the end of December or the end of January to either pay all the arrears and the rent that comes due or leave the rental unit. So after that termination period, the actual eviction is enforced through the court enforcement office, also known as the sheriff's office. So they are the office that actually attends at the rental unit and changes the locks. The sheriff will give the tenant about 10 days written notice of the date and time they will come to evict the tenant. In terms of COVID and tenant evictions right now, there is currently no moratorium on eviction. So tenants are and can be evicted right now. There is repayment agreements during COVID. So there is a newer law that requires the landlord and tenant board to consider whether the landlord has attempted to negotiate a repayment plan. And I have found that repayment plans tend to be longer. So for example, before the pandemic, repayment plans were anywhere between 2 and 3 months long. Now I'm seeing repayment plans anywhere between 6 and 12 months long. Of course, before COVID, I was seeing arrears of $2 and $3 grand, and now I'm seeing arrears of anywhere between $10,000 owing and more. This is a somewhat recent change that I just wanted to bring to your attention, although it did happen in 2018. So now when a tenant enters into a tenancy agreement, they are required to use the standard form lease. The standard form lease is quite long. It is 14 pages long. The last half actually tells tenants about their rights under the Residential Tenancies Act. So it talks about, for example, that the no pet provision is void. So a tenant can, in most situations, have a pet in the rental unit. And then the first number of pages lists the parties, it lists the contact information. So for example, the tenant always has the landlord's contact information. It lists the specific address of the rental unit. It talks about the amount of rent and the term of the tenancy, along with who's responsible for utilities, the landlord, the tenant, whether there can be a rent deposit, which of course is only 1 month's rent, and whether or not tenant's insurance is required. A bit on tenant's insurance, it is something that I recommend. I've seen a number of cases where it actually has not been the landlord's maintenance that's caused damage or caused the tenant to leave a rental unit, but has been some other act that has required them. So for example, a flood to leave the rental unit, and it can help with those costs that the tenant will incur. Recent changes in regards to the Residential Tenancies Act include withholding rent. So often we see that tenants withhold rent because the landlord is not maintaining their rental unit. That is never our recommendation. We would recommend that a tenant continues to pay their rent, because if they don't, they could be evicted for the arrears, and instead file the appropriate tenant application. So for example, a T6 for maintenance and repairs. So the change that happened is before you could bring those tenant issues up at the landlord and tenant board hearing itself. But now you must tell the landlord and tenant board before the hearing about any maintenance issues you want to bring up. So you have to, for example, give a written description of the issues, the remedies sought, and include any evidence. The evidence could be pictures, property standards reports, emails between the landlord and tenant, where the tenant advises the landlord, especially on a repeated basis, of the maintenance issues. And all this evidence is due to the landlord and the landlord to tenant board at least 7 days before the hearing. In terms of the rent increase, for 2022, the rent increase is 1.2%. There was no rent increase in 2021. So just be aware of that. In the year 2021, the landlords were not allowed to increase the rent. On the slide here, you'll see what a typical notice of rent increase form looks like. So the landlord does have to provide this rent increase form. It does give them 90 days notice of the rent increase. And a tenant can only have their rent increased once every 12 months. So in terms of why there's that 90-day notice period, it's essentially because you'll have 30 days to decide whether you want to continue living at the rental unit with that rent increase. And then if not, you'll still have the opportunity to give the 60 days notice to advise the landlord that you're leaving the rental unit. What you should be aware of is that now there has been a change to the Residential Tenancies Act that basically makes an illegal rent legal. So if you pay an illegally increased rent for 12 consecutive months, it is now your valid rent. So for example, if the landlord increased your rent in 2021, which he could or she could not do because it was a 0% no increase, but you've paid it for 12 consecutive months, then that new rent becomes your valid rent. However, to be aware, a tenant can file a tenant application within the 12 months for an illegal charge. So the T1 application is a tenant application for a rebate of money that the landlord owes. It's basically claiming that the landlord charged me an illegal rent. And if you're successful, you would get that rent back, and the landlord and tenant board would make a decision on what your legal rent is. This recent change is potentially huge. So it's pursuing a previous tenant. A landlord can now pursue a previous tenant at the landlord and tenant board. So what does this mean? It means before, if the tenant was no longer in possession of the rental unit, if they were not living there, then the landlord had to take them to the small claims court for any debt owing. So for example, the tenant moved out and the landlord found damage to the rental unit, they would have to pursue in the small claims court. But now the landlord can pursue at the landlord and tenant board for any tenant who's moved out on or after September 1st of this year. And the landlord has to pursue the tenant at least within 1 year. What the landlord can pursue is any arrears or rent owing, damage and utility, and other expenses incurred. So just a bit more on this. So the scope really is that this could potentially bring a huge number of cases to the landlord and tenant board. The landlord and tenant board is a fairly easy process. You don't necessarily need legal representation. You file your application, you get a hearing within, say, 3 to 6 months. Whereas the small claims court does take more work. There's more forms, it takes a bit longer to go through the whole process. It might cost you a bit more. You may not be comfortable with the process, so you would hire a lawyer or a paralegal. And then I'll also mention that previously, sometimes, especially some of the big landlords, would use a collection agency. So for example, a tenant, after they've moved out 3 months later, would receive a call from a collection agency saying, oh, well, you owed rent because the landlord needed to repaint the unit. So that's just a bit of what has happened before. The collection agency is not a legal debt. So essentially, the landlord has to go to the landlord and tenant board now to get that order. It is a court order. So it is enforceable order that can be brought to the small claims court enforcement office to garnish that previous tenant's bank account or wages. So I want to just talk about my other concern in what a landlord is pursuing. So for example, a landlord can pursue willful and negligent damage, but if it's general wear and tear, the tenant is not responsible for that. So general wear and tear could be, the tenant has lived there for a number of years and the walls need to be repainted. That would be general wear and tear. Versus willful or negligent damage would be, there's willful holes in the wall, for example. So there is some concern about what or how or what the landlord will be pursuing there. Another thought is, should the tenant provide the landlord with their new contact information? So when you move out of a rental unit, the landlord will have to serve you with any documents bringing you to the landlord and tenant board. So on one hand, you would want to know about any hearing against you. On the other hand, the landlord is responsible for serving you. Another thing is that now the landlord can potentially serve a tenant through email. So perhaps there is some onus on the tenant to continue checking their email. What happens if they've changed their email? There's just a concern that there'll be a number of applications out there where the tenant is not aware of being brought to the board and did not attend to defend themselves. So my biggest suggestion is, if you're speaking with any tenants, that they take pictures before they move in, along with pictures after they move out, just to show the unit in those two states. Some recent changes have made potentially it to be a bit more difficult for the landlord to be successful in that N12, so the owner or the purchaser moving in, and the N13, the rent evictions. So I first just want to talk about these notices a bit. So the N12, in terms of the compensation that the tenant is eligible for, it's 1 month compensation. If it's for the purchaser to move in, there must be a signed purchase and sale agreement. And the termination date is 60 days. So basically, if a tenant were given a notice today, they would have 60 days to the end of the term, so to the end of January. But of course, they would always have the right to a landlord and tenant board hearing. In terms of the N13, so that is the landlord stating that they need vacant possession of the rental unit to do repairs. It does require that the landlord actually requires vacant possession. So there are renovations that a landlord can do with the tenant still living in there, the unit. And it does require that the landlord has or needs to get a building permit. It's a longer notice period, so 120 days, and the tenant does have the right to move back into the rental unit. Compensation is either 1 or 3 months, and that just depends on how large the building is. So if it's a larger building, 5 or more units, then compensation to the tenant would have to be 3 months rent. In terms of the new requirements, the first one is that the landlord must provide a sworn statement of the person intending to move in when the eviction application is filed. So this is just moving it to when the eviction application is filed instead of providing that at the hearing itself. The landlord must also provide details about any previous N12s or N13 notices given to any tenant in any rental unit in the last 2 years. So that could potentially help with any bad faith eviction notices. Presumably, if a landlord is giving one of these notices to tenants every few months, then it may not be in good faith. And there's also been an increase to the damages that a tenant can get from the landlord and tenant board when they were evicted in bad faith. So what that includes, the new provision, is general damages up to 12 months rent. So this is on top of other remedies. So the other remedies are, for example, an increase, the difference between your new rent and your old rent for 12 months. So if you were paying $1,000 and now your rent is $2,000, then you could be eligible for that increase of $1,000 for 12 months, along with the 12 months rent in general damages. You can claim for moving costs. You can ask the landlord to be fined. And the list of damages does go on. But in terms of what these applications look like at the landlord and tenant board, the bad faith test is essentially 3 parts. The first one is that the tenant received an N12 or N13. This is actually a pretty big part for some tenants to get over, because often a tenant is evicted and the landlord has told them that they will be moving in, but they've never actually received an N12 or an N13. So it is very important, and almost there is an onus on the tenant to assert their tenant rights at that point in time and to require the landlord to provide them with that notice of eviction. So first step, the tenant receives the N12, N13. Second, the tenant actually moved out because of that N12 or N13. And then the third part is the owner or the purchaser did not occupy the unit like they said they would in the N12, within a reasonable time, or the landlord did not renovate like they said they were going to do in the N13 within a reasonable amount of time. And then just some things that the tenant will have to show or could show to prove bad faith is obviously the landlord advertises the rental unit for rent, enters into a tenancy agreement with someone else, or advertises the rental unit or the building for sale. I wanted to talk a bit more on accommodation in housing. So landlords have a legal duty to accommodate when a tenant is disabled or for other grounds under the Residential Tenancies Act to the point of undue hardship. That point of undue hardship could change depending on the landlord. Is it a small landlord that owns 1 unit, or is it a large landlord that owns 60,000 units? So some of the things that a landlord could be required to do would be make changes to the unit's bathroom or the kitchen to make it more accessible, the entrance or parking areas. It also includes mental health disabilities, for example, so how a tenant communicates with the landlord. So for example, only in writing, only to a support person. I've seen cases where a tenant does suffer from some mental health disability, and their accommodation is that if a neighbor or a landlord notices that there is an issue, they will contact a family person, a support, or their support person to get the person the help that they need. The tenant does have to provide relevant medical or personal information, not necessarily what the disability is, but that there is a disability, and because of the disability, this is the accommodation that the tenant needs. So this is something that we can help with. And this is something that can be brought in front of either the Human Rights Tribunal or the Landlord and Tenant Board if the landlord is not accommodating the tenant. And finally, I just have one more thing that I wanted to talk about, and that is rent geared to income issues. So what I'm referring to is someone who has a subsidy, so whose rent is according to their income. So this could be through the Region of Waterloo, Kitchener Housing, Thresholds, or a nonprofit. The types of decisions where we get involved is, for example, if a tenant has lost their subsidy due to missing tax information to verify income, if they are overhoused, meaning that, say, a child has moved out and now they have too many bedrooms, if they are if there's an unauthorized occupant. So for example, someone has moved in and either they have not provided their income or they're not authorized to move into the rental unit. Again, this is for rent geared income units. Or if they've been denied access to the centralized wait list in terms of special priority, so getting to the top of the wait list because of domestic violence or trafficking, or not being eligible because they owe arrears to a previous social housing provider. So we can help with the review process. There's generally a 30-day deadline for that. And I want you to be aware there are some new laws for rent geared to income units. I think if there's anyone from the region, they might be able to speak to this a bit more afterwards. But this is my understanding of the more recent changes. So rent is now based on the income tax return, as opposed to providing other information from employer or ODSP pay stubs, for example. The tenant does not need to report increases of income unless there's a new member of the household or their taxes have been reassessed. However, rent is not recalculated monthly. So the tenant can ask for a reduction in their rent if their income has decreased 20% or more. They can also ask for a reduction in their rent if they start or stop Ontario Works, ODSP, or full-time school studies. If the tenant has been at market rent, essentially if they've been employed and making enough that they're at market rent for up to 24 months, the subsidy can still be reinstated. So this is up from 12 months. So this is good. They don't lose their subsidy as quickly. If their is, say, a transfer or coming into rent geared to income housing, they can only be offered one rental unit, not 3, before there's a chance of losing their subsidies. So just a couple things that I wanted you to be aware of. If the household has lost their subsidy basically within the last year, that increase in their rent would start January 2022, because rent geared to income housing did not increase rents in the year 2021 because of that legislation that said there was 0% rent increases for this last year. So sometimes I find that tenants aren't really aware, although they've been provided with letters about their rent until it actually starts. So that's something to be aware of. And then something else to be aware of is that the CERB or the Canada Recovery benefits that a tenant had received during the last year could affect their rent starting in January. So of course, if you've seen that, if someone had said, well, my rent's gone up, but if they're now have starting or stopped Ontario Works or ODSP, they can ask for the recalculation of their subsidy. So just be aware of those issues and connect with myself or connect with the region if you have any questions on those. Finally, this is my list of super helpful resources that you should be aware of. First of all, property standards. So contacting the city in regards to any heat, plumbing, structural, or water issues is very helpful. It is also very helpful to get a copy of that report, although a tenant may have to do a Freedom of Information request. That report can be used as proof at the Landlord and Tenant Board if the tenant has filed a T6 maintenance application. It makes it a lot easier to prove that you should be receiving remedy because the landlord is not maintaining the unit when you've got a copy of that property standards report. The Rental Housing Enforcement Unit, I term them the housing police. They are funded through the Ministry of Municipal Affairs and Housing, and they are very helpful with illegal evictions. So by that, I mean, if there is a tenant who's being evicted without going to the Landlord and Tenant Board, you could phone the Rental Housing Enforcement Unit and they are helpful. I mean, generally what they do is they have that conversation with the landlord and said, this is the process that you have to follow. You cannot evict a tenant without going to the Landlord and Tenant Board. The Social Development Center has an eviction prevention program and a couple of workers there, Holly and Michelle, who have been quite helpful and on the ground preventing evictions. So they're a good person to connect with if a tenant requires that in-person at their house support. The Waterloo Region Police are quite helpful as well. During the eviction moratoriums, they made sure that tenants stayed housed. They are also helpful for illegal evictions. They will often also have that conversation with the landlord, telling the landlord that this is a Landlord and Tenant Board issue and you need to go through the Landlord and Tenant Board if you want to evict the tenant. Community Legal Education Ontario is brought to you by our group of community legal clinics with easy to read legal information. So if you have any questions today that you just want to look up, you're welcome to call me, or you could look it up on stepstojustice.ca. And of course, you're welcome to connect with us at Waterloo Region Community Legal Services, either connecting with your client. If you yourself have a question and you would like to, on a no names basis, just get a general idea of a legal issue that your client is experiencing, you're welcome to connect with me. Facts are also helpful because the facts will change the outcome, but I'm happy to ask or answer general questions as well. So this is my contact information. Please feel free to contact me anytime. And then, yeah, so I'd like to open it up to any questions.
Thank you so much, Kristen. There's a couple questions for you. The first one is, if a renter had to move out because of a renovation, you said that they need to be offered to move back in. Can the landlord raise the rent if they move back in?
No. So it is as if the same lease continued on. So it would be at the same rent as well.
Thank you. Another one.
I should say in those cases, it's very important that the tenant asserts that right. So they've advised the landlord in writing that they intend to move in. They provide the landlord with their new address or their temporary address and contact information. And I would suggest contacting the landlord, especially in writing, on a frequent basis to determine when you can move back in. But also in those situations, it may be helpful to even if the tenant is moving out, it may be helpful to bring it to the board to begin with. So potentially it could go into a mediated agreement. So the tenant agrees to move out by such and such a date. The landlord will do the renovations and the tenant, and then we'll contact the tenant and give the tenant notice before they're allowed to move back in, for example. So it could be helpful to still assert those tenancy rights, even if you agree that you're moving out, and even if the landlord agrees that you can move back in.
Thanks, Kristen. Another question is, when you were talking about the standard form lease, what about smoking and non-smoking units?
My understanding is that there's generally no smoking units anymore, and it does list that in the standard form lease.
Thanks. Can you clarify if a tenant should provide their landlord their forwarding address when they move out?
So sorry, say that again. If the tenant should
provide their landlord the forwarding address when they move out.
So we've had discussions in the legal clinic about what to do with that. I would suggest giving your landlord your forwarding address. Yes. Others have thought that, well, the landlord has to serve you and they have to find out your address if they were to pursue you for claiming damages, for example, and put the onus on the landlord. But I would prefer to provide the forwarding address and then to fight any claim against me as a tenant and to know about that.
If someone did have their rent increased in 2021, can anything be done about that now?
Yes. They should contact us immediately. So if there was an illegal rent increase, a tenant can file a T1. So that's a tenant application about an illegal charge. But they've only got 1 year to file that. So if they started making an illegal payment, an illegal rent payment, a legally increased rent payment on January 1st of 2021, they've only got till the end of this year to make that T1 application. So they should be doing that immediately.
Another question is, can collections pursue someone receiving Ontario Works? And what does that look like? For example, can they garnish the OW?
Good question. So those types of income supports cannot be garnished for consumer debt. Ontario Works cannot be garnished. ODSP cannot be garnished. Canada Pension Plan, Canada Pension Plan Disability, OAS, GIS. In some circumstances, WSIB can be garnished, but generally most or all income maintenance programs can't be garnished. So you're essentially garnished proof. So your bank account and your wages cannot be taken from you for a consumer debt. And I say consumer debt because government debt and support payments are different. So we'll take those out of the calculation, but for landlord and tenant board orders, bank account and wages cannot be garnished for income supports.
There's a lot of questions for you. If a tenant is disabled and receiving PSW assistance, who is responsible for pulling out appliances at the landlord's request? The PSW could be at risk for injury while on the job.
Okay, so if it's a unit that needs to be accessible, then that would be the landlord's responsibility. So the general steps for that would be, I would get a letter from, if the tenant has an occupational therapist, for example, or a family doctor, briefly saying that because of the tenant's disability, they require a certain stove, and it is the landlord's responsibility to accommodate, so to make those changes to the point of undue hardship. So if the landlord is not accommodating, then the tenant can pursue, and the tenant would pick their forum of being the landlord and tenant board or the human rights tribunal.
Thank you. Are there any supports for immigrant families that do not speak English or speak little English and are having difficulties navigating the system, including when the landlord does not respond to requests for repairs?
So we do have interpretation services. So if the tenant can contact us and we can arrange an appointment with an interpreter. From there, we may be able to contact the landlord with the tenant's consent to make that request to them. There may be some services as well. Jump in, anyone, if you know, but perhaps Reception House. Is anyone else aware of any services that could be helpful?
KW Multicultural Center.
Ah, perfect. Yes. Thank you. KW Multicultural Center.
Hi there.
Someone.
Sorry, I'm a nurse from SOS. I just have a question as well. Sorry, I'm just scrolling up here to read this question. So I have a client that was given an N12 form, 90 days until December 31st to move out. The landlord is moving their parents in because their current residence is getting demolished, so they would need a space. This tenant currently lives in a triplex. She's been there on the top floor for about 7 years, and she was there when the landlord bought the place. The other 2 units are occupied, but they're paying more rent than she is. She kind of grandfathered into this building, and she's only paying $800 versus the people that are paying $1,550 below, like on the other units. So she was just asking if she has any rights to her unit because she does not want to move out. And yeah, just any advice that I can give her or who she can reach out to.
Yeah, so she can definitely reach out to us and we can take a look at that notice. So sometimes notices are void because of deficiencies in the notice itself. So, you know, dates. The tenant does have to get the compensation before the termination date. She would always have the right to a landlord and tenant board hearing. So even though this sounds like it could be in good faith, if she needs more time, then I would recommend, well, the landlord can pursue her through the landlord and tenant board. So she does not need to leave at the end of next month. She would have that right to a landlord and tenant board hearing. In terms of if it is in good faith, there is unfortunately case law that says that the landlord can pick the unit. So one of the reasons that the landlord could pick that unit because it has the lowest rent, but it would still have to be in good faith. So the landlord's parents moving in, for example. But yes, please have her contact us because it's helpful if we review the notice, potentially represent, even if it's just to give her more time at the landlord and tenant board and to give her some other suggestions.
So then the date of December 31st, that could possibly be extended to a different date?
Yes, yes, that's exactly what I'm saying.
Okay.
So the landlord would have to apply to the board. The landlord could apply now, or I believe within 30 days of that termination date, so by the end of January. Then she would get a hearing in front of the landlord and tenant board. It's probably going to be end of January, even into February at the earliest before she gets a hearing date. She should be taking steps and diarizing her steps that she's taken to find a new unit, because I mean, with our housing crisis as it is not easy. But if she diarizes the steps that she's taken, she could present those steps to the board and ask for more time. It's not unusual for tenants to get 2 or 3 months more time to find a unit. So if nothing else, it could be, a few months down the road versus the end of next month before she does face that eviction.
Okay, I know that the landlord had offered to help her find a unit, but because of her income, she can only afford, what she's paying right now. And it's just been very tricky. Even the landlord had offered, but everything is over like $1,300 and she's just not able to afford that. She does have a mental disability. So I suggested, for her to reach out to you regardless, just to kind of see, if there's anything she can do around that part. And I told her, you don't have to disclose your mental disability to your landlord. That is your personal health information. So they don't have to know that.
Right, yes. Luther Wood may be helpful, if nothing else, than assistance with last month's rent deposit.
Okay. Thank you so much for answering that.
You're welcome.
Thanks, Kristen. So someone else has asked, they've heard of tenants receiving eviction notices, but the landlord had not gone through the LTV. What are the repercussions for landlords before the changes?
So if so a tenant can leave pursuant to an eviction notice. So if they've received that N4 for arrears or N5 for damage, they can leave by the termination date in the notice. And if they've done that, then that's been essentially their decision that they don't want to enforce those rights. But otherwise, if the tenant wants to fight that eviction, dispute it, ask for more time, then the landlord does have to apply to the landlord and tenant board for an eviction hearing. So am I answering your question fully? Is there more to what you'd like to know about there?
Sorry, I can ask this question by audio. So I was speaking to somebody who mentioned that when you're handing out an eviction notice to tenants, you have to apply through the landlord tenant board, or can a landlord give an eviction notice to a tenant without doing that?
Yeah, so a landlord can give an eviction notice without actually applying to the landlord and tenant board. So
Okay.
that happens a lot, say in the N4. So that's the one they owe arrears. It's almost a warning or a reminder. So it's basically saying, you owe me this money by this date, and if not, I will apply to the landlord and tenant board. But if they do not apply to the landlord and tenant board, and the tenant does not have to move out and the tenancy continues on.
Okay.
Does that help? Or
yeah, I mean, it's a bit more complex because there's a lot of cases where there's a lot of landlord harassment involved, and I think they're really trying to get the tenants out, so they'll try everything possible to give them eviction notices, and some tenants aren't aware of their rights. So a lot of them, just think, oh gosh, I need to move out, without thinking that they can apply. They can approach the landlord tenant board and fight for their rights.
right.
So a lot to take advantage of that. So
yeah, so I would contact us with that eviction notice, and we can take the tenant through their rights. And then it's kind of tricky at what point does it become harassment? So if there's valid reasons for giving a notices, or the landlord thinks that there's valid reasons for giving a notice, and that is part of the landlord's right to give those notices. But at what point is it harassment? And then if it is harassment, then the tenant can apply to the landlord and tenant board a T2. So that's a tenant rights application. So the landlord's interfering with my reasonable enjoyment, but the landlord's harassing me, and can pursue in that way. So they can connect with us and we can talk about their options there.
Okay, thank you.
You're welcome.
Thanks, Kristen. What should what should the caseworker do if they've received a call from collections? This person had received one and have not responded, and they've referred the client to the legal clinic, but not sure if the client is connected regarding the collections.
Yeah. So there's a number of outcomes. So one thing that I would want to know is, has the matter gone to the landlord and tenant board or to the court before? Because if there is an order out there, there's the potential that that order, whether it's a landlord and tenant board, a small claims court order, can be enforced. So meaning it can be brought to the small claims court enforcement office, where there would be garnishment of the person's bank account or wages. Of course, there's only garnishment of the bank account when there are wages, and Ontario Works and other income supports cannot be garnished. But otherwise, if a creditor has not gone through that collection, then it's not an enforceable debt, which means the tenant can disagree with that debt and they do not have to pay. The debtor would have up to 2 years to bring the tenant or person to the small claims court, for example, for an order. So generally, some of the advice I give is about that limitation period. So when does the limitation period start? So for example, say it's credit card debt and you haven't made payment in 10 years, then, and you haven't been sued, then it would be beyond likely the limitation period for that credit card company to pursue you. But if it's been within 2 years or you've made payment recently, then there's the potential to still be sued. And then end of the day, there are certain laws that a collection agency must follow. So certain times and the amount of times that they can connect. The Ontario.ca website has very helpful information on the rules a collection agency must follow. So I would recommend Googling that. So just collection agencies in Ontario, and it brings you to the Ontario.ca website, which talks about that. But if the person sends a letter that says they dispute the debt and ask for it to be taken to court, then the collection agency is not allowed to contact that person any longer. So I can talk hours about collections, so maybe I will do another presentation on kind of debt and collection issues, another lunch and learn on that coming up soon.
That would be awesome. The next question is, some rental companies do not allow tenants to smoke on their unit's balcony. Is that legal?
Generally it is. I don't know the exact answer for it. But oftentimes a landlord will provide a smoking area. So, somewhere slightly away from the building. Smoking is really how it affects other tenants. So the potential to be evicted for interference of another tenant. So that's an issue. There's also the potential for accommodation. So depending if there's medicinal marijuana, although there's not necessarily a right to smoke in at the unit, but there could be an accommodation request for the landlord to provide a smoking area somewhere on or around the rental building itself. So I don't know if that answers your question or if there's more you'd like to talk about there. But it's definitely a big issue that we see coming up.
On that, someone has asked if they have black mold on their carpet due to water leaking in through their balcony door. What are their rights around that?
Yes. So first thing I would do is put it in writing to the landlord. Dear landlord, this is the issue. I'd like it addressed or inspected by the end of next week, for example. I think contacting property standards is helpful, although sometimes my understanding is that they don't get involved with mold, but I would check with them. And then if not, the tenant can apply to the landlord and tenant board So they would be filing that T6 application. That's the maintenance application. There is a cost to file landlord and tenant board applications, but depending on the income, the tenant may be able to fill out the fee waiver, and it would be free to file. So anyone on Ontario Works, ODSP, or other forms of assistance or low income, it is free to file a tenant application. Tenant applications, they're not addressed very quickly, but it could be almost a few months down the road before it is brought to the board, if not longer. And then remedies include out-of-pocket expenses, abatement in rent, which is a decrease in rent, an order for the landlord to fix the unit, are examples of that.
Thank you. Okay, I have 3 more for you. If living in a unit where the tenant is sharing a kitchen with the owner and given a good faith N13, does the tenant get any compensation?
So if a tenant, they share a bathroom or a kitchen with the owner?
A kitchen, yep.
Yeah. So if a tenant shares a bathroom or a kitchen with the owner, they are not protected under the Residential Tenancies Act. So I think the policy behind that is it's your home. And if you have someone come and stay with you, let's say an old friend from high school who's coming to stay with you, and then they overstay their welcome, they aren't a tenant. So you can ask them to leave at any point in time. So this person sounds like they're not protected under the act. If they share a bathroom or kitchen with the owner of the property or certain close relatives, it means they can be asked to leave at any point in time. There is essentially a contract potentially between them. So if there's an agreement between them, that could be brought to the small claims court. So they could sue under the agreement. So if there was an agreement between them that the landlord would give notice before an eviction and didn't, then that person that living with them could sue them for any damages there. But yes, if you share a bathroom or kitchen with the owner, you don't have the right to a landlord and tenant board hearing or any of the provisions under the Residential Tenancies Act in terms of compensation.
Thanks, Kristen. And then another question, can a landlord start renting out apartments as Airbnbs? And then if they're asked to move out because they want to move into your unit, is that possible?
So are you asking if someone can be evicted so that the landlord can start using it as an Airbnb? If that's the case, then no. There's only certain grounds that you can be evicted for. So for example, rent, damage, landlord's own use, but landlord's own use as in they're living in the unit, not intending to rent it out otherwise. Yes, so I should mention that I've seen a lot of cases recently where landlords are trying to buy out tenants, and quite substantial amounts as well. So I've had tenants where the landlord is willing to give them anywhere between $10,000 and $25,000 to move out of the rental unit, and it's likely because of the housing market right now. So that, on one hand, that seems like it could be a lot of money to tenants. On the other hand, the increases in rent are so substantial that it may not be a benefit to them. End of the day, they always have the right to that landlord and tenant board hearing. But at the landlord and tenant board hearing, there's only certain compensation that the board can give them. So it's a conversation that I have often with tenants, and it's essentially up to them on how they want to proceed. Sorry, that was a big tangent. I can't even remember the question now.
It was about renting out Airbnb.
Oh yes. Yeah, that tenant should contact us so we can review the notice of hearing with them, but it doesn't sound to be valid.
Thank you. And last one, can someone directly contact you regarding issues with renovations to their unit?
So if it's a tenant, then contact us either by the phone number there or on our website contact form. So the process is they'll likely speak with Jordan of our office first, and then if they need help or representation, they are often put through to myself, Veronica, or Cynthia for possible representation. For support workers, if you have a quick question, you're welcome to email me. I'm sometimes not as fast as responding than Jordan. So honestly, sometimes it's quicker just to give us a call at the front desk. He's pretty quick. But I'm happy to do kind of that secondary consultation, as in to the support worker. So you can ask me by my email address there.
Thank you so much, Kristen, and thank you everyone for attending today. We hope this information was helpful to you, and we hope to work with you in the future. So thank you again.
Thanks, everyone.
Have a good afternoon.